hospitality and for your generosity towards us. The end is near. Soon, or at least within 30 days, the trial of the Hancock 38 should be over. The judge, the prosecutor, the defendants, and the lawyers who have so generously volunteered their services to help in our defense can all breathe a sigh of relief and move on to other things, perhaps including a penalty for the defendants. But it won't be over for the people of Afghanistan, Pakistan, Yemen, Somalia, and so many other countries for whom the death toll by drones mounts. Since April 22nd, when our action occurred, drones have killed between 250 and 360 human beings in Pakistan alone, according to the New America Foundation. These numbers probably don't include the deaths of 16-year-old Tariq Aziz and his 12-year-old cousin, Wahid Khan, who were killed by a drone strike in Pakistan on Monday, the day before our trial began. We are charged with 2 counts of disorderly conduct. The statute states, hopefully this will be the last time you'll hear it for a while, a person is guilty of disorderly conduct when, with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, he obstructs vehicular or pedestrian traffic, or he congregates with other persons in a public place and refuses to comply with a lawful order of the police to disperse. The evidence presented in the case, including the testimonies of James McKenna and Lieutenant Daly, clearly establishes that we did not act recklessly. We were, in fact, pretty orderly, certainly not up to the standards of military precision, and I doubt that anyone who has spent nearly a week with us in this courtroom could possibly believe any claim that we acted with military precision. I suspect that Mr. Young and Mr. Van Ostrand would be the first to raise objections to any such claim on my part, but we were still pretty orderly. We walked. We did not run or use threatening gestures or language. Most of us lay down, wrapped in bloody sheets to symbolize the victims of drone attacks. 2 sat in their wheelchairs. 1 stood with her cane. Hardly a reckless action. It seems then that we are left with the statute's language about intent. The statute employs intent in a fashion that is broader than the standard definition of criminal intent as intending to perform the act which is deemed criminal. Here, intent to cause public inconvenience, annoyance, or alarm refers to what I, as a sociologist, would consider to be motive, the reason or purposes for the act. The language of the statute opens the door to discuss our motives for this act, and you have allowed us to do that. The evidence clearly shows that our intent was to petition our government for redress of grievances, as epitomized by our attempt to present the indictment of drones on the basis of international law to base officials. In conjunction with this, we intended to act symbolically in a way that would raise the consciousness of the public about the harms caused by the use of drones to kill human beings overseas. We did not intend to cause public inconvenience, annoyance, or alarm. We simply intended to petition our government for redress of grievances and to raise public consciousness and perhaps conscience about drone killings. We believe that drones violate international law and that under the Nuremberg principles we have an obligation to publicly express our opposition to killing by drones through nonviolent action, as testified to by former Attorney General Ramsey Clark, who has directly influenced many of us through his writings and through personal conversations. Drone killings violate the Nuremberg principles in that they are a crime against peace when used in nations which are not a war zone, and war crimes when they are used within a war zone. Although the government claims that they are precision weapons, the continued killing of civilians, most recently Tariq and Wahid, puts the lie to such claims. Killing on the basis of remote imaging fosters a high-tech fog of war which destroys innocent human beings. Drone attacks in Afghanistan, Pakistan, and elsewhere have killed thousands of human beings, many of them innocent civilians. Such high-tech remote killing breeds deep hatred of the perpetrators among neighbors and relatives of the victims, who see death striking out of the sky with no pilot putting his or her life even minimally at risk, an ever-threatening, unseen hand of death previously imaginable only in science fiction. Dealing death while sitting safely at home, thousands of miles away, can only be viewed by those on the receiving end as a cowardly, evil act. The increased use of drones blurs the distinction between war and peace, and as noted by Council of Foreign Relations fellow Micah Zenko in his book Between Threats and War, makes it politically easier for the president to order killings in countries with which we are not at war, because there is no risk of lives of American troops. This increases the likelihood that he will use drones, thus increasing the risk of incidents which could lead to even more wars. Drones also create the threat of a new arms race. Drone technology is much easier to develop than nuclear weapons technology. A number of nations besides the United States have already developed them, including Israel and China. The specter of a world in which both state and non-state actors can launch drones to target any individual they wish, remotely controlled from half a world away, is a nightmarish world, a world we do not wish to bequeath to our children. Furthermore, drones make upstate New York a war zone. Drone pilots at Hancock Field kill people in Afghanistan. By international law, that makes them combatants and therefore legal targets. Even when they're off duty, they may be considered legal targets. That makes all of upstate New York a war zone. What happened? What happens when a suicide bomber decides to target a legal combatant, a drone pilot at Hancock, when they're sitting at a soccer game, watching their kids play soccer? We believe that we have exhausted our legal alternatives. Collectively, the 33 defendants have engaged in centuries of voting, petitioning our government leaders, signing petitions, writing letters to the editor. I dare say, and I don't think anyone would contradict me here, that Cynthia Vanis alone has done more of this sort of petitioning than the average small town put together. We believe that nonviolent civil disobedience is an important component of any movement for social change. We have acted as part of a causal network of individuals and organizations which are using a variety of tactics, including civil disobedience, to try to change government policy with respect to drones. As a social scientist, I know that there are an increasing number of studies which indicate that nonviolent direct action is more likely than violence to be an effective instrument for change. Peter Ackerman and Jack Duvall's book, A Force More Powerful, A Century of Nonviolent Conflict, documents dozens of cases of successful nonviolent action. Erica Chenoweth and Maria Stevens' Why Civil Resistance Works uses quantitative social scientific methods to conclude that nonviolent methods are more effective than violent approaches to social change. And as I've mentioned, on a more philosophical level, John Rawls, in his classic Theory of Justice, argues that principled nonviolent civil disobedience is necessary for the proper functioning of the democratic legal system. And Your Honor, you sort of stole my ending because you came up with my point when you were questioning me, but I'll repeat it anyway. I acted on Good Friday because I firmly believe in the nonviolence of Jesus Christ, of Martin Luther King, of Mohandas Gandhi, of Dorothy Day. Gandhi said that when you do civil disobedience, you should plead guilty and ask for the maximum penalty. I should explain again why I did not do that. I do accept responsibility for my actions on Good Friday, and am willing, although not eager, to serve the maximum sentence if convicted. In pleading not guilty and making the arguments I have made, I was trying to create an opening for you, Your Honor, to use our gift of this action to speak to our national crisis. I wish you would find us not guilty, not because I do not want to assume responsibility for my actions, but because a verdict of not guilty, which acknowledges our arguments, would be one more voice for goodness in the face of evil. Your voice, like ours, would be a small one in the larger scheme of things. However, to have a United States judge speak in court or in a written decision of the illegality of drone warfare would be a ray of hope for all who seek peace. Us who's down in Whoville might finally be heard. And so, Your Honor, I am asking for a sign of hope. Without hope, there is